going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. Hope you guys are having a great day so far. I've got a good one for you. This one, you know what? I don't know where this court is. I've covered it a few times. I need to check on that, but it is in Michigan. I do know that much. Okay, this one is a divorce sideways. They don't even bring up the divorce. They're dealing with all the other things that are going on, and there's a lot. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back lips. Let's go.
Amanda Rogenbuck on behalf of plaintiff Chad Hornbacher, who is present and seated to my left.
Good morning, everyone. Would you bring us up to date why we're here?
I certainly will, Judge. Ms. Hornbacher typically has an attorney. I don't know if he's coming or if she's representing herself at this point. He is on him via Zoom.
Oh, yes, sorry.
It is, Judge.
Good morning. Can you hear us?
I can, yes.
I called the case. My name is Fred Borchard. I'm here by assignment to assist with the docket here in Huron County. And I've asked for the appearances and introductions of the parties. That has been done on the record. If you'd be kind enough to give us your appearance, please.
Jacob Perron on behalf of Terry Hornbacher.
All right, and your client is present.
Oh, I immediately feel bad for this judge. He is there by assignment. It's not even his normal chair. Ah, man. The other judge took a good day to take off.
Correct.
Turn the matters over to counsel at this point. May proceed.
Thank you, Judge. So the court has a bit of history in this case. Judge Krill has been here for the whole time, but I will bring the court up to speed. This case started in December of last year. To date, there have been no responsive pleadings filed. The defendant has been defaulted twice and is currently in default. She was subpoenaed on the first subpoena with the due date of February 26, 2024, and required at that time to provide all medical records, mental health treatment, diagnosis records, and prescription records from January 2021 to present for herself. She was again subpoenaed with the due date of April 26, 2024, to provide the following with regards to the minor child. The minor child subject to the matter from July 1st, 2023 to present, any and all medical treatment records, any and all mental health treatment records, any and all lab orders and test results, any and all medical orders and test results, any and all dental treatment records, any and all invoices for the above services, any and all payment records for the above services, any and all diagnosing results for the above services, any and all prescription records for the above services, and any and all records, whether submitted to insurance or paid by cash or unpaid. To date, we have received zero compliance on Ms. Hornbacher's subpoena regarding her records and somewhat partial compliance as of last Friday on the minor child's records. What the court needs to be aware of is June 7th, Judge Krill entered an order to compel, requested that my office submit an invoice for costs. We did that. There was no objection to the invoice for costs. We received nothing until last Friday. As of last Friday, Ms. Hornbacher was kind enough to turn over a copy of the record that she didn't even request any records on the minor child until June 6th, the night before the hearing. When my office received the email with some records, I am sad to report that we received only partial reports, exactly one statement for medical records from a billing from McLaren, pieces of documents, pieces of pages, records that have pages cut off. In short, Judge, there's no way for my office to determine where these records go because there's no way to organize them. What I can report to the court is absolutely missing from those records are mental health treatment, dental records, invoices with the exception of one page, No EOBs have been provided, no payment record, no prescription or prescription payment record. Ms. Hornbacher was ordered on June 7th to provide the documentation by June 14th. That failed. Last night, my office received the only other email we received from Mr. Perone after our office was closed saying, call me, let's settle this. We are past the point of settling. Ms. Hornbacher does not appreciate or follow the rules of this court. She doesn't follow the rules that guide the parties. She has zero regard for the orders of this court over and over. We've had to default her twice, Judge, in this case. Again, as I said, on the 2-8 subpoena, we've never received any compliance. The motion is lengthy, Judge.
All right, I wanted to let her finish, but I think she might go on for a couple more minutes. Why do they need her dental records? I mean, I guess everything else makes sense, but dental records? I don't know why that would be relevant in a divorce hearing. So that's what the whole base of this case is. But one of the parties, the female and her attorney, aren't providing the records. So yeah, they're upset, and they've had to default her twice, is what the attorney says. Yeah, this is going great for them. But still, dental records, really?
It lays out the entire history of this case and how we got to this point. But what's critical is the court knows she's been defaulted twice. She's been ordered to turn over records by June 14th. She has done nothing to comply with the subpoena about her records, nothing that's helpful to comply with the subpoena about the minor child's records. I'm asking the court to hold her in contempt. I'm asking the court to jail her until compliance is received. I'm asking for fines and costs from the 7-7 hearing that he entered. The court has already received it. No objection was filed. I'm asking for all fees and costs associated with this hearing. I'm asking the court to bar her from further discovery, as you are allowed to do, and enter a default judgment in my client's favor. And given that there may be a time that we get more information, if we do receive documentation, I would ask for a 90-day trial adjournment, because there's absolutely no way we can be prepared for trial in less than 2 weeks.
Trial set.
August 15th, I believe, Judge.
Is there a response, counsel?
I'm more than agreeable to a trial adjournment. I did provide her with over 100 pages of medical records that were relevant to all of her inquiries. So as far as zero compliance, I don't think that was necessarily the case. Unfortunately, they did get stuck in my inbox, so I didn't get them forwarded in time. But Ms. Hornbacher actually got them to front of the court before that. And I didn't hear anything in regards to requests until the motion to compel from the other side. I anticipated they had received them from front of the court potentially, but that was my error. Been some issues lately that have stretched our office pretty thin, and unfortunately we are in a default stage right now, but I will file a motion to set that aside on the for relief from it and set it aside so that we can deal with these issues. Is there's already the requirement that there's some type of an equitable division that is done, even if there's a default. And in this case, it's pretty straightforward. There aren't too many facts associated with it. There was a thorough investigation done by friend of the court, and default doesn't apply to custody. You don't have to interrupt me. I gave you an opportunity to talk. As far as jail.
Yeah, that was an objection. I mean, by definition, an objection is a form of interruption, right? And the judge doesn't even rule on it. They're just, you don't need to interrupt me. Yeah, no, I objected. I mean, come on. This attorney is something else.
And fines, we've provided a significant amount of records, so I will make sure that we get whatever additional exists over to Ms. Rogenbuck so that she can have that, and we can proceed to trial in an expedient fashion. Although, this case doesn't really lend itself to a trial, but we can definitely go that route if we need to. And as far as the ticky-tack defaults, there wasn't a date that was specified the last time as far as when it would be due. So that's kind of, unfortunately, my oversight, but it wasn't specified in an order. So my argument to set that aside or for relief from it at this stage is got to do with the overall efficiency of dealing with the situation so that we can move it forward. But the verified financial information form in this case is the property is mainly with Mr. Hornbacher. He has most of the property, and he's the one that hasn't filled out a verified financial information form, from my understanding, anyways.
The counsel's brought to the court's attention, and listening to what she said, the records have nothing to do with property, correct?
No, these are medical and mental health treatment records for the defendant and the minor child, who she had sole possession of, because until we had a court order in place in January, she refused to let my client see the child. She took the child missed 41 days of school while in her possession. We have no idea where this child went. We have no.
All right, if that's true, that is unacceptable. 41 days. I mean, even if you take it, you get custody of your kid and you take your kid on vacation, 41 days of school is extremely excessive. I mean, how many days do you have to miss for truancy to kick in? I would think 41 is it. I don't know where you draw the line on truancy, though.
Way of gathering it. Opposing counsel is incorrect. The order judge signed said he had 7 days from June 7th to comply with this order. It's very clear. He received a copy of the order before it was signed. He received a copy of the order after it was signed. And he was present by Zoom when judge ordered him to turn it over within 7 days. That request was also the motion that judge granted. There's never, to address him, there's never been a VFI filed on his side. He's never filed an answer. VFIs have never been triggered. The defendant doesn't follow rules. And at the last hearing, Judge, I know that you weren't here, so I will provide you this for your information. Mr. Perone said he was looking forward to zealously having a trial and litigating this. Well, now we're a month later, and now there's not really a trial necessary. Mr. Perone and the defendant's position changes every time that we are in court. But at the end of the day, there are 2 lawful subpoenas they have not complied with. My client is hemorrhaging money to try to keep his daughter because the defendant doesn't think he should have contact with her. That's not what the courts found. That's not what any law enforcement agency or the Department of Human Services found. The defendant is stonewalling because she doesn't want the information to come out. 2 legal subpoenas and an order to compel have already been entered by this court along with 2 defaults. There is 0 reason that she shouldn't be held in contempt. And again, I reiterate the request that I made.
As I indicated, I had the documents in front of the court, had the documents within that 7-day period. Unfortunately, as a result of my oversight, it didn't make its way to Ms. Rosenbach, and I didn't hear about it until the motion to compel. And then I sent them over there, and apparently they're not enough for what she wants at this point in time, which isn't out of the ordinary for these types of requests, but we have attempted to comply with it to some degree at least. And I think that it's not going to be very difficult to get everything figured out in a very expedient fashion going forward with any additional records that may or may not be appropriately necessary. But if we're going to talk about contempt, we're going to talk about a hearing, which I think is absurd at this point. And frankly, I'd be the one that would be in contempt because I'm the one that didn't turn the records over. I don't feel like that oversight amounts to.
Yeah, I mean, I understand what he's saying. He's trying to take the heat for his client. But here's the thing. The client didn't turn over the documents multiple times when asked. And then just 1 day last week, they got stuck in your inbox. Like, if that's a 1 day delay because you missed an email with all the documents, especially they said over 100 pages. So it's a big email. I get that. But that was 1 day. Sounds like you've had months to comply. Yeah, you can fall on the sword all you want, but yeah. But good job on advocating for the client, taking the heat.
Contempt, and there was not any egregious conduct that was intended here, although that's consistently attempted to be inferred by the other side. There's no nefarious actions. There has been nothing to interfere with the visitation. The plaintiff, Mr. Hornbacher, has had all the visitation that he's been entitled to up until this point in time. He actually has the opportunity to schedule the visitation, which he's done so in a very difficult and vindictive way to skew the schedule in his favor.
For contempt regarding 2 subpoenas.
All right. I want to talk to counsel in chambers, so we'll get counsel. So, let me see also.
All right, for those of you that couldn't hear that, because the judge did speak really softly, the judge just asked us to speak to both counsel and chambers. Yeah, probably tell him to calm down. And he's a pro tem judge, so probably just kind of trying to figure out what's going on and how to schedule this further. He wasn't the judge on the case for all the other hearings, so he probably has no idea what to do at this point. Now, he's a judge. He's probably seen stuff like this before. I shouldn't make comments like that. All right. I'm going to let this video play out. Hopefully you guys are having a great Friday. And yeah, don't forget to hit that like button. Until next time, bye.
Defendant, would you give us the dates, Ms. Hatch, on where we're going to proceed from here, please?
October 16th at 9 a.m. For the continued contempt hearing and all other motions. And then the divorce trial date will be Thursday, November 21st at 9 a.m. And the court will send notice.
Mr. Brown, I'm a little curious why you weren't here today for the hearing.
We called in prior to the hearing and were informed that we could appear by Zoom.
But you had told the court, am I correct, that it wasn't going to be a contested matter?
I didn't tell my assistant called the court and just explained to them what was going on today. There was a motion to compel hearing. As I understand.
All right. Well, as politely as I can tell you, I would want you here for Judge Brill at any of these future hearings. So, and we cover all those dates then.
Yes.
In regards to the trial then.
Yep.
All right. And then in the interim, if you could identify to the best you can what records have been received, what are still doing on. With that to Mr. Brown, in the hopes that maybe they'll be able to respond. The records aren't turned over. And I've listened to what he said, that he didn't get them to counsel here, but the records that are still missing, if they are still missing, if they are not turned over, there's a good possibility it could be held in contempt of court and locked up until there is compliance with that. So you've got to make sure that those work with your counsel. You got to make sure those records are they've been subpoenaed. So
if I could know what hasn't been given to council because I've submitted. So I have.
All right, so
plus refreshed on June 6th. So yeah, I like to know
all right,
what she has not received yet.
all right, well, share the record what they were good.
Yeah.
And she's going to be kind enough to have those typed up. So
Right.
you got to make sure that compliance is.
And
The last, don't interrupt, please.
Oh, I'm sorry.
The last thing I want to do, and I know Judge Brill wants to do, is lock anybody up. So I need you to work closely with your counsel on that. All right, you understand that?